Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello, listeners. We're talking today about the Internet of Things, or IoT, and specifically how to manage vendor cybersecurity risk when you're contracting for IoT technologies. My name is Julian Dibbell, and I'm your host. I am a senior associate in Mayor Brown's Chicago office with a practice focusing on technology transactions. Our guests today are my colleagues, Marcus Christian, Linda Rhodes, and Charlie King. Marcus and Linda join us from our Washington, D.C. office. Marcus is a partner in Mayor Brown's cybersecurity and data privacy practice, and Linda is a partner in our technology transactions practice. Charlie is an associate in the technology transactions practice and joins us from our Chicago office. Good morning, everybody. Good afternoon, wherever you are. Charlie, tell us a little bit about the Internet of Things and why it might create a heightened security risk relative to other kinds of digital technologies.
Thanks, Julian. Sure. So the Internet of Things, or IoT as we'll refer to it in this discussion, is a system of connected computing devices that can transfer data over a network without human-to-human or human-to-computer interaction. Use of IoT devices continues to grow exponentially as companies continue to leverage its impressive data collection abilities, which is driving exciting new developments in a range of fields. And it's actually estimated that by 2025, there'll be over 64 billion IoT devices in use worldwide. And as the world becomes more increasingly connected, cybersecurity vulnerabilities are amplified because we have additional endpoints that provide threat actors with more means to reach critical systems through more sophisticated and varied cyber attacks, which can result in a range of harms such as business interruptions, financial loss, and even personal injury.
So, Linda, what kinds of businesses are impacted by IoT risks, and how are they impacted?
Yeah, so Charlie really, gave us the mouthful of information that's really important, but I'm going to try to break it down into a couple of examples. So, first you have companies that are engaged in manufacturing IoT products. And what they do is they'll embed technologies from one or more vendors into their products, include some of their own technologies and the like. Then you also have IoT that comes up in an enterprise context. A good example is, let's say, supply chain. So traditional supply chain distribution involves human intervention. You send somebody a request for something, they've got to fulfill that request. As demand grows larger and larger, that becomes less efficient. And so you can implement a ton of IoT solutions like inventory control systems, data feeds to the distribution centers to send the message to send out product and the like. And this can create, significant efficiencies in your process. Due to the heavy reliance on vendor technologies and implementing these types of IoT solutions, vendors really play a critical role in ensuring cybersecurity. Managing vendor cybersecurity is part of any company's overall cyber program.
Okay. What about the COVID-19 pandemic? What impact has it had on IoT and on related cybersecurity risks?
Well, as everyone knows, the COVID-19 pandemic has led to a large movement of people moving to a working from home environment instead of working from the office, whether it be from stay-at-home orders or social distancing requirements. So we now have a larger number of workers who are working at home, logging in remotely to different systems, who are communicating digitally and interacting with colleagues and clients digitally from their homes or other remote locations. And as the infrastructure for remote working is implemented and improved, the chances of a return to the pre-COVID-19 status quo is becoming less likely. As an example, so as the shift to work from home continues, manufacturing plants are increasingly using IoT devices to collect and analyze data as opposed to collecting and analyzing such data in person and on site, which creates a greater cybersecurity risk for that data in question. The COVID-19 pandemic has also created a lot of unique cyber threats and security challenges for different businesses, given the remote work environments and how they are unlikely to maintain the same level of security safeguards as those that are maintained in the systems at actual work facilities.
Marcus, you follow regulation in this area pretty closely. How has the U.S. approached regulation of IoT?
Now, given the upside of innovative technology and the significant consequences of security breaches, quite a bit of thought has gone into how to mitigate cybersecurity risks associated with connected devices. Now, lawmakers have weighed in through many legislative efforts, and the resulting legislation reflects a clear understanding that there is a need to protect connected devices and to manage vendor cybersecurity.
And what legislation is currently in effect?
Okay, so when we look at federal IoT legislation, it's been proposed in the United States. However, the U.S. federal government has not yet passed any of it into law. Now, California often is a leader in legislation, and that is that is certainly the case here also. California recently became the first state to enact an IoT-specific law, and that law took effect on January 1st of 2020. California's law requires manufacturers of connected devices to equip these devices with a reasonable security feature. The reasonable security feature or features must be, one, appropriate to the nature and the function of the device. Two, it needs to be appropriate to the information that it may collect, contain, or transmit. And three, it must be designed to protect the device and any information contained on the device from unauthorized access, destruction, use, modification, or disclosure.
Okay, so California out in the forefront of regulation, as is often the case. What about other states? Are they following along?
Well, in a sense, other states have enacted laws designed to ensure the proper management of vendors when it comes to cybersecurity and data privacy. For example, Massachusetts, which has a strong reputation for having robust data security laws, requires companies to take reasonable steps to select and retain third-party service providers that are capable of maintaining appropriate security measures to protect personal information. Massachusetts further requires companies to third-party service providers by contract to implement and maintain appropriate security measures for personal information. Now, one thing to keep in mind is, although a state like Massachusetts doesn't have a specific IoT law, when a regulator is investigating a cybersecurity incident, particularly one that is high profile, if it impacts sensitive information and there are significant numbers of victims, the lack of an IoT security law is not going to be an impediment to vigorous investigation and potentially stiff fines and penalties.
Got it. What about on the federal level? We don't have federal IoT legislation, but what are the federal laws that would come into play in any case?
So many industries have laws and regulations and standards that impact IoT, and this just shows how complex the field really is. So, for example, companies need to consider whether there are regulations that are applicable to their businesses that affect IoT solutions. For example, the Graham-Leach-Bliley Act, Department of Transportation and the NHTSA safety regulations, autonomous vehicle technology guidance, FDA rules and regulations, and many others. It's important to note that we have both laws, regulations, and guidance directed specifically at cybersecurity, but then we also have laws, rules, regulations, etc., that impact the safety of IoT solutions. So if, for example, a cyber vulnerability does not necessarily raise a safety concern, but if a threat actor can take control of an IoT device in a way that endangers the user, then that may become a safety concern. Take the connected vehicle space as an example. Hackers have been able to use the entertainment system to access critical driving control functions. Just the access to an entertainment system itself, isn't necessarily a safety issue, doesn't raise safety concerns. It could raise some privacy and data security concerns. But once they can access or use the access to that entertainment system to then gain control of vehicle functions, you further have a safety issue to be concerned about. Additionally, federal agencies like the Department of Homeland Security, Department of Commerce have provided guidance on how to manage the security of connected devices. Federal Trade Commission has asserted its authority to bring enforcement actions for, quote, unreasonable IoT security practices.
And what do we know about what's going on outside of the U.S. In other jurisdictions, for example, the EU?
Yeah, and I don't want to get into necessarily a deep dive in this podcast on global cybersecurity and data privacies, but it is worth mentioning the EU Cybersecurity Act. It became effective in June 2019. It takes a somewhat different approach. It focuses on certification of ICT, or information and communications technology, products, services, and process, which in essence are IoT devices that are sold in the European Union. While the approach is a little bit different, the purpose is the same. It's to make IoT devices safer and more secure, recognizing that security and resiliency are not yet sufficiently built into products, services, and processes.
Okay, so let's review here. California's new IoT law requires that connected devices have, quote, reasonable security features, unquote. The FTC has asserted its authority over, quote, unreasonable IoT cybersecurity practices. Under Massachusetts law, companies are required to cause third-party service providers to implement and maintain, quote, appropriate security measures, unquote. But what do these terms really mean? What is reasonable? What is appropriate in this context?
Sure. So as Marcus alluded to earlier, California is often at the forefront of data privacy legislation in the United States. The California law provides some guidance on what constitutes a reasonable security feature. First, the security features must be appropriate to the nature and function of the device and the information the device may collect, contain, or transmit. Therefore, for example, a connected device that collects personal entertainment preferences in order to provide entertainment value to a certain user may require different security features than a device that collects and transmits financial data to accomplish financial transactions, or that collects and transfers personal health information to monitor or treat health issues. California law further requires the reasonable security features be designed to protect the device and any information contained therein from unauthorized access, destruction, use, modification, or disclosure.
And how, Charlie, does your description of the California law requirements relate to managing vendor cybersecurity risk?
Well, these principles not only need to apply to the company's IoT components and technologies, but they must be extrapolated to its vendors in order for the company to meet security obligations applicable to it, and in some cases, legal mandates pass through such security obligations. Failure to do so can result in regulatory violations, as shown by the FTC's willingness to bring claims against device manufacturers that fail to exercise proper oversight of their service providers.
Well, and vendor contracts we often see will include a covenant for the vendor to implement and maintain reasonable, appropriate, and adequate security measures and safeguards using those, all the right magic words. But is that enough?
So Julian, yes, companies typically include a covenant in their vendor contracts requiring reasonable, appropriate, et cetera, security measures. And in fact, as we've talked about, many laws require companies to include that in their vendor contracts. However, if a security incident arises and regulators come after a company, plaintiffs ask you to demonstrate that a security feature was in fact reasonable, appropriate, and adequate. Just pointing to a single sentence in a contract is not a winning strategy. So from a contract perspective, you need to go further. requiring that security and safeguards be sufficient for compliance with laws, compliance with industry standards, such as those published by the International Organization for Standardization, the International Electrotechnical Commission, and the National Institutes of Standards and Technology. That demonstrates a more focused approach to security to actually, identify some of these standards. Also, where applicable in a specific industry, there are specific industry regulations and standards. For example, again, in the connected vehicle space, the recently adopted, SAE ISO 21434 standard, sets cybersecurity engineering road standards. There's the WP29, which was promulgated by the World Forum for Harmonization of Vehicle Regulations. All this takes cybersecurity principles and sets specific standards in the vehicle context. And so similarly, whether you're healthcare or some other kind of financial services or whatever, you want to take that deeper dive into what specific industry standards your vendors should be following.
Okay. And are there other steps the company should consider?
Well, exercising due diligence is just of ultimate importance. Generally when you're engaging vendors, but specifically looking at cybersecurity due diligence. Sometimes the hardest part is just knowing what questions to ask, right? And so your due diligence checklist should include many items specifically related to cybersecurity diligence. For example, what is the function of the vendor's technology? What information does it collect, store, and transmit? What protective features have been designed into the device technologies? So first step, obviously, is to ask those questions of your vendors, and then have conversations and request documents and other information to support the answers. Like, make the deeper dive. Don't just rely on answers from your vendor. Actually get the backup documentation supporting that. Then further, in order for a vendor's component or technology to work, what are the connections to other critical components of the devices? Again, just back to my earlier example on vehicle lane departure warnings and backup systems. Data collected from a radar technology needs to then connect to the vehicle warning system, and for advanced technologies to even connect with the driving functions, the critical driving functions of the vehicles. Sometimes the question's not just a simple one. One vendor may not fully comprehend the full solution of the IoT device. There may be connections the vendor's not aware of because there's multiple other vendors involved, and the company may perhaps be in the best position to take a look at that. But surely you need information from each vendor in their cooperation in really doing a comprehensive analysis.
Marcus, I noticed that the California Consumer Privacy Act, the CCPA, it doesn't, while it's not specific to IoT, it does have provisions that might be particularly relevant to cybersecurity in the IoT context. It requires, again, these reasonable security features. It requires that they must be designed to protect the device and any information contained therein from unauthorized access, destruction, use, modification, or disclosure. In other words, the security features must not only provide these protections, but must do so by design. And what in this context does by design mean?
Well, in a common sense, it's security at the outset, not security as an afterthought. And more specifically, security by design is an important and pervasive concept in cybersecurity. The first step for a company to determine whether its vendor components and technologies were designed with security in mind, in particular if the company is acquiring or licensing from a vendor technology that predates or is developed outside of the contractual relationship, is to ask the question and follow that up with further diligence. Depending on the nature of the technology and its purpose or use, security questionnaires and audits may be needed to fully assess the security design features. Many companies, and in particular those companies in regulated industries, already face regulations and guidelines imposing by design obligations such as safety by design and privacy by design. Cybersecurity by design is yet another layer of due diligence investigation. As a result of the CCPA imposing an obligation on companies to ensure security by design, these questions are no longer relevant only to autonomous vehicle technologies, medical devices, and the like, but these are principles to be applied across all connected devices. Many vendor contracts include representations and warranties that vendor products and work product comply with documented specifications, but consider whether to expand these representations and warranties to state that such products and work product were and will be designed with security in mind.
Okay, Charlie, how will a company demonstrate that contractual requirements, in particular those pertaining to security features and security by design, have been adhered to?
The company can use its audit rights to demonstrate those things, but the audit rights need to be sufficient to allow the company to access people, processes, and information that are all necessary to ensure compliance with those obligations throughout the term of the contract, including in cases where a cybersecurity incident arises. For example, where a claim arises under the new California IoT law, you may need to demonstrate that the technology embedded in a connected device was designed with cybersecurity in mind, as Marcus was alluding to. And a typical right to audit contractual compliance may not extend that design information unless you've thought to put it in the contract.
And who needs to be able to exercise that right to audit?
Well, just in general, the company and its auditors for sure, but also cybersecurity experts engaged by the company to help with the investigation of a security incident. If a security incident occurs, for example, or is even suspected or threatened, outside counsel may engage a third-party cybersecurity expert to conduct the audit. Of course, the company can do that also, but for reasons I'll mention in a moment, it often makes sense to have outside counsel do that. Among other things, the information discovered by such a third party may be discoverable in the event of an investigation or litigation. And we know when the investigation comes in the wake of an incident, there's all sorts of sensitive information that may be revealed. And that's why you want to have outside counsel engage the third party vendors, such as a forensics company. Legal counsel, outside legal counsel in particular, can engage auditors under privilege and enjoy certain benefits such as privilege and confidentiality, as well as potentially work product protections that could be relevant in the event of investigation or litigation.
And how long do the audit rights need to last?
Well, an enterprise IT vendor contract may permit the company to audit a vendor during the term of the agreement and a tail period after the agreement ends. You need to consider that a contract for connected technology that may be embedded in devices used by the company's customers long after the contractual relationship expires.
Okay, great. So, Linda, what are some of the key takeaways here today for our listeners?
Yeah, the contracting recommendations that we described in this podcast are by no means exhaustive, but they're intended to provide context and considerations for companies managing vendor cybersecurity risk in the context of IoT. To build a comprehensive cybersecurity contracting strategy, companies need to understand the legal landscape. We talked about IoT laws, other laws that impact IoT, even if they're not directly governing IoT. You need to manage vendor risk from the very beginning, the by design concept that Marcus referred to, and throughout the life cycle of the devices.
All right, good things to keep in mind. Thank you, Linda. Thank you, Marcus, and thank you, Charlie, for your insights today. Listeners, if you have any questions about today's podcast or anything else related to technology transactions and the law, please email us at techtransactions@mayorbrown.com. Your question will be forwarded to the appropriate presenter for a response. And thanks again for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.